lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today's Tuesday here at 10 a.m. on the Bottled Business Sense show. Welcome back to all of our regular viewers. And if you are new to the show, hey, welcome to the Bottled Business Sense show. We stream bi-monthly here on YouTube, Facebook. You can also catch the replays on iTunes. The links to, I believe it's LinkedIn and Twitter. And anytime you want to look at the library, just go over to our YouTube channel. And we have a whole host of episodes over the last 7 years, huh, Bill?
Somewhere in there, 7 or 8, yeah.
Yeah, something like that. So welcome to the Bottle Business Sense Show. I'm Rick Moscoso, one of your co-hosts, and I will bring on and introduce Mr. Bill Bernard for our topic today.
Thanks, Rick. And one correction to what Rick said, a little tweak there, is that we used to regularly go bi-monthly. We used to actually go years ago every, I think it was once a week.
Yeah, every Tuesday.
So, yeah. So we don't go, technically we haven't been on bi-monthly, even though that's what we try to do. We have busy schedules, so forth and so on. So really what you want to do is follow us, or you just want to check on our various media platforms to find out when the next show is going to be. I typically advertise it a day or two ahead of time. So it's not necessarily going to be bi-monthly per se. It may be once a month, it may be 3 times a month, it may be once every 2 months. It depends on when we're able to get to the next show and get it to air and have Rick prepare it and so forth and so on. So make note of that. The other thing I wanted to address before we get started is questions I've been getting on various media platforms, and I think most of them come on YouTube. Remember that these general questions you're sending in, that the purpose of the show is to give you the general information, not to prompt you to send in more questions about general information. What you do after you listen to a show is go see your attorney, retain an attorney, and find out what you need to do and adapt the general principles of law that we provide you on the show, the general principles of law, to your specific situation by having a sit down in person with an attorney or on the phone with an attorney that you retain. Retain means you sign up and you sign a retainer agreement and you pay the attorney for services that he or she is going to perform for you. So, general questions that try to extrapolate further things that apply to your situation based on what you've heard in the show just isn't going to cut it. You need to have a conversation with an attorney you've retained as it applies to your situation. Again, what we provide you are general principles of law that you take, grab onto, and then go see your attorney and talk to your attorney about those principles as they apply to you. Okay, so what we're going to do today is talk about some general principles about what a will won't do. And I'm going to bring in a little bit of information at the end of the show that is kind of a teaser for the following show we're going to do. And you'll see how that all fits in a minute. But I want to talk about what a will won't do, because there are some major assets that fall outside the scope of a will. Now, I've talked a lot about trusts in the past. We're going to get to that, but let's assume we're starting out with a will. You hear on TV shows all the time, well, he or she didn't have a will, or he left this to you in the will. They never talk about a living trust, but most people are familiar with a will. And remember that if you have a will, you still end up in probate court if you don't have a trust, because without a will, the laws of intestate succession determine who gets what from your estate, and that's determined by a probate court by using and adapting the laws of intestate succession. If you have a will, you still go to probate court. It's just that the will overrides the laws of intestate succession and say, okay, here's who's going to get what. But you still got to go to probate court. You still got to go through that nightmare of time and effort and money that's going to be spent from your estate because you didn't have a trust. So we're going to start with a will, and we're going to say, okay, most people are familiar with a will, but here's what a will won't cover, and here's some solutions that you can get to get around the probate nightmare, whether it's not using a will without a trust or not using a will and having a trust. So we're gonna try to approach it in that manner. So let's start out with the assets that do not fall within the scope of a will, assuming that's what you want. Assuming, hey, I want a will, the heck with a trust. It's too expensive, which it isn't, but that's another story. Retirement accounts. Retirement accounts would include Iras and 401ks. So you need to talk to your plan administrator or investment firm about how you want to handle these at the time of death. Now, most people understand that IRAs and 401ks are not typically, sometimes they are, but not typically put into a living trust. And they have nothing to do with the will, because IRAs and 401ks have their own beneficiaries attached to them. And therefore, they act like their own, I don't know, you might call it a mini trust. They have their own beneficiaries. So if you name a beneficiary in an IRA and a 401k, you don't need to worry about probate court, right? So you need to speak to your administrator for that IRA or 401k. And you need to make sure that you have your beneficiaries named. Remember, a couple of tips here. An ex-spouse could still be the beneficiary of a 401k, for example. So you need to be careful of that. You get divorced, you need to change your beneficiary. Call your administrator and make sure that beneficiary is changed. Another problem can be if no primary beneficiaries are alive and no contingent beneficiaries are listed. So when you call your administrator, make sure you have the beneficiary or beneficiaries that you want to get your assets in your 401k or your IRA. But make sure you have contingent beneficiaries named in case that beneficiary, the main beneficiary or beneficiaries, die before you do. So those are two issues you want to look forward to, or and resolve if necessary in a retirement account, either a 401k or an IRA. You call your administrator, you make sure that you have contingent beneficiaries in addition to the primary beneficiaries, and you make sure that if you got divorced, the next spouse isn't still listed on your account as a beneficiary. Let's take life insurance policies. Life insurance policies also have beneficiary listings, and that determines who gets the money to the policy when you pass. You could accidentally leave a policy, again, to your ex-spouse. So again, you need to make sure your ex-spouse is not named on that life insurance policy as a beneficiary, except when. You have any idea, Rick? When you would leave an ex-spouse on a life insurance policy as the main beneficiary, even though you're divorced? Have any idea?
Well, I could see in an example maybe that there aren't any other living children, or could that be an example?
Well, that could be.
You don't have any children? Maybe,
and maybe you get along with her and you're still in good terms. But here's the real reason. A lot of times life insurance policies are part of the divorce settlement agreement. And so you're required, pursuant to that agreement, to leave your ex-spouse on the insurance policy as a beneficiary. So remember that, but you should affirm with your insurance company who you want to be your beneficiary. And again, look to primary beneficiaries and contingent beneficiaries. Contingent being if the primary beneficiary dies before you, you have somebody who's still going to get the funds.
So in that case, Bill, let me just ask you a question. In that case, is there any risk to changing the beneficiary on the life insurance policy if that's the case?
What do you mean when you say risk? What do you mean by risk?
I mean, it won't affect the policy at all if you change the beneficiary on your life insurance policy, will it?
No, not at all. No.
Okay.
No, you have a right to name who you want to get your money when you die. So yeah, it's really as simple as that. So no, not any issue there, Rick, at all. So we've talked about retirement accounts, which include 401ks and Iras. We've talked about life insurance policies. Now let's talk about a third vehicle, which would be bank accounts. If an account is titled as a transfer on death account, typically known as a TOD account, payable on death, a POD account. So TOD, POD. If you have that type of account, or you have a joint tenancy with right of survivorship account in your bank, that would override the will. The will won't cover that, just like it won't cover Iras and 401ks and life insurance policies. Your account signature card at your bank will indicate what type of an account you have. So for individual accounts that are titled TOD or POD, the beneficiary can simply go to the bank with proof of identification to transfer the funds into a new account in his or her name only, or to simply withdraw the funds and close out the account. For an account at the bank that has a listing of joint tenancy, you will also need, in addition to your identification, a copy of the death certificate. So make sure you understand that these bank accounts, these three different type of bank accounts, are ways to get around probate and are items that a will not cover. So if you have a will and you're going to probate court because you don't have a trust, these items that we've talked about so far are not covered by that will and can be done outside the scope of probate court. And again, what are they? Retirement accounts, which consist of 401ks and Iras, insurance policies, life insurance policies, and bank accounts that we just talked about, the three kinds, which would be payable on death, POD, TOD, which is also a payable on death account. It's just entitled differently. And then, of course, we have a joint account, a joint tenancy account. So TOD being transfer on death, POD being payable on death, and then right to survivorship, joint tenancy. The acronym for that is JTWROS. Anyway, you need to go to the bank, show identification with the joint tenancy account, identification, and the death certificate. Let's talk about a category number 4, which is real estate. If you own a home in joint tenancy with right of survivorship, again, similar to the bank account we just talked to, that home will pass automatically to the person who is in joint tenancy with you. It has nothing to do with probate. It has nothing to do with a will. If you have a will, you don't need to worry about going to probate court with regard to that property because joint tenancy is going to override that will. So even if you leave that property to somebody in your will, it's not going to work. The joint tenancy is going to override that will because that person who's on joint tenancy title with you is entitled to that property in whole once you pass. Then that person goes and transfers the property into his or her name alone. So that's real estate. Now let's talk about, I guess it's category 5, but it really is living trusts. Trusts, you need to be aware that under the 2019 Secure Act, which was passed by the federal government, and this is kind of a tease for our next show. We're going to get into this more in our next show. So let me lay this out for you. The 401ks and Iras that we talked about in the very beginning of the show, the retirement account aspect, that are covered without the need of a will. You leave your beneficiaries and that's who gets your money. The question then becomes, can you put retirement accounts and Iras in your trusts? Well, the Secure Act passed by the federal government, which runs Iras and 401ks, they have put limits, basically a 10-year limit on when you can stretch out these payments from IRAs and 401ks to the people you leave as beneficiaries in the trust. So now picture this. You have an IRA and a 401k, and instead of leaving primary beneficiaries of individuals and contingent beneficiaries of individuals, you instead leave the living trust that you prepared, the name of the living trust, as the beneficiary, in the hopes that the trust terms saying who gets what when will then disperse the money from those IRAs and 401ks to the people you want it to go to, and again, without the need of probate, right? Now the question is, how long can you spread out these payments if you have a beneficiary who's got certain problems? And that's what we're going to cover in our next show. And we're going to cover the Secure Act, as well as how long you can stretch these payments out. We're going to address what's called an accumulation trust. So be aware of that, an accumulation trust. We'll talk about that in our next show. So in closing the show today, there's a couple things I want to pick up on, going back to what we originally discussed, and a couple things you need to be aware of. When listing beneficiaries in these accounts that are not covered by a will that we just talked about, make sure that you include the names, the social security numbers, and the relationship of the beneficiaries to you. And if you have multiple beneficiaries, make sure you disclose the percentages you want each beneficiary to get. Okay? That includes the primary beneficiaries and any contingent beneficiaries. If you just want it to be split equally, say that. But you need to tell your administrator that, and make sure that the numbers total 100% if you're divvying up who gets what when you pass away from these accounts. Use words precisely. Money goes to a primary beneficiary or contingent beneficiary only if there are no, money goes to a contingent beneficiary only if there are no primary beneficiaries. You want to make sure you spell that out, okay? Don't make the mistake of listing a child as a primary beneficiary and another child of yours as a contingent beneficiary. That can cause some real problems, okay? So you want to try to avoid that. Next, stay current. Life events such as marriage, divorce, birth of a child, death of a beneficiary are good reasons to review your paperwork on your 401ks, on your IRAs with your administrator, on your life insurance policies with your life insurance company, and even on your bank accounts with your banks. Okay? You want to update these things periodically and make sure that they're up to date. That's very important. Otherwise, what you've done is meaningless. And then finally, work with an attorney and spend a little money up front in order to avoid bigger problems down the road. Now, you might think, hey, Bill, I'm going to be dead. What do I care? Don't be selfish. Remember that you have loved ones you're leaving your estate to. That's the people that are going to be mired in a bunch of problems, not to mention expense. They're going to have to pay out of the estate, which reduces the money that they're going to get or the assets they're going to get. So make sure you deal with a lawyer up front to have these things done properly, and make sure all your ducks are in a row so you avoid the problems down the road, at least in terms of your heirs, so they're not hassled after you pass. Okay? So again, recapping, this is what a will won't do. We have these accounts that you can use and establish and avoid probate even if you have a will. These same accounts are good and avoid probate in the manner I've described, even if you don't have a will. What's the moral of that story? Well, the moral of that story is whether you have a will or don't have a will, you're still going to probate court. You're still going to spend money, and you're still going to spend time and effort in terms of your heirs, that is, and your estate. Because will or no will, you're going to probate court. Purpose of today's discussion is to say, hey, if you have a will and you're going to probate anyway, you at least don't have to go to probate for the items that I've listed for you, because you can name beneficiaries that are outside the scope of a probate court's jurisdiction, as long as there's no dispute between the funds and the distribution of those funds. Again, best idea to do it is to have a living trust And then these items that I've discussed today are still outside the scope of the trust, but now you avoid probate altogether, even for the assets that don't fall within these vehicles that we discussed today. For the next show, I'm going to talk to you a little bit about how you put these assets that we discussed today in a living trust, so should you so choose, rather than naming individual primary and individual contingent beneficiaries. Okay? So I hope that's helped out. That should do it for today, Rick. And remember, this is intricate stuff. I mean, it's pretty basic and straightforward, I believe. But when it comes to questions about extrapolating from these issues and going further and having it done right, as I mentioned at the end of the show, that's when you need to retain an attorney. You can't just get online and ask general questions. You need to adapt the questions that you have to a specific situation that you have, to a specific lawyer that you retain. Can't emphasize that enough. Okay?
Yep. I know you've talked about this before in previous episodes about getting these types of resources online. Can you comment on that? I mean, there's a lot of platforms that they can just sign up for. They can get a will, get a living trust, and just do it online. I know you feel very strongly against that, and can you explain maybe briefly why?
Sure, because of the reason I feel very strongly against it is specifically for the reason I just stated earlier, and that is these people that have these programs that you download have questions that you follow as you go along, and they depend upon you, the non-expert, the non-lawyer, to put in information correctly, and then the document is printed out, as opposed to a lawyer taking the information you have and adapting it pursuant to law in the manner that it should be according to your specific situation. These people with these programs have no idea of your specific situation. They give you no input for the most part as to your specific situation. They rely upon you to provide the input, and then the document is printed out without any review or any suggestions by them. Now, some places, such as LegalZoom, those kind of issues, you can retain a lawyer and you can do what you need to do for an inexpensive price. But are they going to be there for you in the long run if you need to change something or if you need to sit down and get some advice? I don't know. I would rather have a relationship with an attorney who I know and trust, who I can call up, who knows my name, I know their name, and that I can have around when I need that person. The other sites that you're paying are at a reduced minimum. They operate over the internet. They have no other expenses, so they can offer you lower prices. True, but do they really care specifically about your individual situation, or is it more like a meat market? I don't know the answer to that. I'm not gonna try to pull the wool over your eyes, but my supposition is that if I have two choices, I'm going to want the personal relationship, even if it costs me a little more money, versus the quick in and out, and the hope that this person will remember me the next time I speak to him or her. So that's what you have to, evaluate. What are you getting for your money? Do you get what you pay for, kind of thing? And then you have, of course, the programs I spoke about initially, which are just with no lawyer interaction whatsoever. You just download Willmaker or whatever it's called. You buy a program, you download it from the internet, and then you do your own thing. It's kind of like I don't know, maybe like TurboTax. I would never use TurboTax. I go to a CPA that I trust, who knows my situation. There are things that are, people have asked me a lot of intricate tax questions. I'm not a tax attorney. I refer them to a tax attorney. So I want the expertise of the individual I retain, and I want that personal relationship so that individual knows my past and can tell me what to look out for in the future and what I need to do as it regards the individual return I'm filing in for a particular year. So anyway, you take that for what it's worth. My website at pye365.com or protectyourestate365.com. You can get to that either way. those URLs provide you with general information in terms of videos and drop down questions that you can get answers to. But again, they're general ideas that pique your interest. So you say, hey, gee, this is something I need to know more about. It's not the be all and end all to that particular issue. It's to pique your interest. So you then say, hey, I'm going to go an attorney and find out more about what Bill's telling me about in general here on this website. Okay?
Yeah.
General
Yeah.
information.
And I love that website because the way, Bill's a former professor, and he has a way about teaching. And I think if you go to that website and you watch some of those videos, it's very educational, very informational. So then you can go on and make your own decision based on the information that Bill provides.
Right. And then thank you, Rick. And Rick built the site, so he ought to know how it maneuvers and how you navigate it. And it's very straightforward, very easy to do. So I would suggest that you get an education, and then once you get the basic education, so you can talk intelligently to a professional, then go and retain a lawyer and get this stuff done, no matter what it is. Even in the other areas we cover, like employment law, if you have a small business, or if you need asset protection, you need an LLC. I can tell somebody generally how to prepare an LLC, but so can the California Secretary of State website or any other state website that you go to. That's not the purpose of the show. The purpose of the show is to give you information about an LLC, let's say, and now have you say, gee, is it right for me? Let me call and retain a lawyer to see if it's right for me. Not general question, hey, how do I establish an LLC? That's not giving out legal advice. That's just pointing you to an area where you can find out a basic set of facts on how to do it yourself. I'm not here to teach you how to do it yourself. I'm here to teach you facts so you can then use those facts in the law to go retain a lawyer. If you're not interested in doing that, then I'm not going to be very helpful for you, because I'm not going to just create something out of thin air by you watching a show. You need to go get your own lawyer. Now, your own lawyer could be me if you decide to retain me. If we have a phone call and the shoe fits and you sign an agreement and a retainer, okay. But you got to do that with somebody. You just can't continue to ask general questions and expect that attorney to provide you with information that's specific to you and your continuing adapting, lifestyle. You can't do that. That's what invites lawsuits. Okay, so take that for what it's worth, and use your common sense, and you'll be fine. Okay, so our next show is going to deal with what I indicated about these vehicles that avoid probate. Now, what if you want to put them in your trust? How do you do that? And over what length of time can you do it? And what government controls are in place to prevent you or to allow you to do it under specific circumstances? So having said that, I hope everybody has a great, profitable week, and we'll see you next time on the show. Right, Rick?
You got it. All right, everyone. We will see you next time on the Bottle Business Sense Show. And remember, you can always watch our video replays on Facebook or on YouTube at Bottle Business Sense Show. And we look forward to seeing you in the next one.
Yeah, and look at bottlebusinesssenseshow.com, Facebook, a Bottle Business Sense Show, LinkedIn, Bottle Business Sense Show, Alignable. I have an account on Alignable. There's a number of different places you can find out about when the next show is going to be. So that's what I would check to determine when it's going to be, because we don't always know exactly when the show is going to air. It's always going to be on a Tuesday at a specific time. Excuse me, of course, but when that date is going to be, we don't know all the time until we get up and get a wild hair and say, hey, we got to do a show, and we have some free time. Okay.
All right, everyone. We will see you next time.
Thank you.